The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon. My name is Lisa Hamameh. I'm an attorney at Foster, Swift, Collins & Smith. I have been practicing law now for 15 years. I started my practice in municipal law. I have kind of branched off and I do some liquor licensing work, and so I have the background a little bit on both sides, but I am a municipal attorney as well, so I have some of that extra insight for municipal bodies. This is not a seminar that talks about liquor licensing from A to Z. What this seminar really is an update to what has changed in the last few years. I'm sure you've heard that the Michigan Liquor Control Commission has changed the rules regarding local government authority regarding the regulation of liquor licenses. Well, it's been a couple years now and the dust has settled, so where does that leave us? Before we get started, I really just want to go through just a few terms with you. I will be talking about on-premise liquor licenses and off-premise liquor licenses throughout this seminar. So I thought it'd be helpful if I give you just a little bit of a background on that. An on-premise liquor license allows for the sale of beer, wine, and spirits for consumption on the licensed premises. What that means, for example, it's like a restaurant that serves alcohol to its customers while on the premises, while in the restaurant, for consumption in the restaurant. An off-premise liquor license allows for the sale of beer, wine, and spirits for consumption off the premises. For example, a convenience store that sells packaged beer, wine, and spirits for its customers to consume once they leave the store, off the premises. There's two types of off-premise liquor licenses, and I will be making the distinction today. So the two are SDD, which stands for Specially Designated Distributor. An SDD license specifically allows the sale of beer, wine, and spirits, whereas an SDM liquor licenses, which stands for Specially Designated Merchant License, allows the sale of beer or wine only, not spirits, meaning not liquor. The way I formatted the rest of this PowerPoint is, in order to tell you what the update is, I need to give you a little bit of background. So the top of this PowerPoint shows, this page shows local approval. Essentially, it tells you that prior to July 1, 2012, local government approval was required before the Liquor Control Commission would issue a new license. So that's a license that's not been previously issued before. Or approve the transfer of an existing license. So that would be transferring, say, the owners of the license or shares of interest in the license or even the location. Essentially, local government had veto power. This understanding of the rules was based on the way the previous administration at the Liquor Control Commission interpreted the code and the rules. So the next slide, as you can see, has the same heading, local approval, but in all caps, update. So the purpose of this slide is to really tell you what the update is. And it's been a couple of years, effective July 1 of 2012, the MLCC changed the way they interpreted that rule. They changed the procedure at the Commission by requiring local government approval only for new on-premises liquor licenses. What does that mean? It means local government approval is not required to transfer an existing on-premise liquor license, to issue a new off-premise liquor license, or to transfer an existing off-premise liquor license. So this update in 2012 essentially meant that local government no longer had that veto power it once enjoyed over liquor licenses transferred into their community. Again, this change was based on the way this current administration at the MLCC interpreted the code and rules. It was not a change to the legislation. The law and the rules are the same. It's the way it's being interpreted. The MLCC wants everybody to know that they are going to continue to consider the opinions of local residents, the local legislative body, and the local law enforcement agency in accordance with their rules. The rule they're specifically identifying is a rule that lists out the qualifications and factors that the Commission will consider in determining whether to approve an applicant for a liquor license or for a permit. One of those factors is the opinions of local residents, the local legislative body, and the local law enforcement agency. Oh, I moved too fast. The MLCC will provide notice of a pending application, but it's not going to provide you the forms that it once did. Those forms are going to have to come from the applicant. Really, that's the update as it relates to approval of liquor licenses. There is an update to entertainment permits. And again, I'm giving you a little bit of background. Prior to December 4th, 2012, the Liquor Control Commission required local government approval for all applications for dance permits, entertainment permits, topless activity permits, and extended hours permits. Now, that was in addition to their approval of that permit request. Well, a case came down in 2012. SA Restaurant sued Andy Deloney. Andy Deloney is the commissioner of the Liquor Control Commission. And at the end of that case, it came out that the court said that the law that required MLCC approval for various permits, which included dance, entertainment, topless activity, and extended hours, was a prior restraint on expressive activity. Therefore, they held it unconstitutional and unenforceable. Where does that leave us now? The MLCC no longer requires local government approval for dance, entertainment, topless activity, or extended hours permits. The Liquor Control Commission, in an effort to aid municipalities, police, applicants, licensees, created a very helpful chart that you could follow. They're called local approval charts. I found this quote interesting, so I just put it in this slide for you. It does specifically state on their website that the Michigan Liquor Control Commission values input from local governments and local police agencies when making decisions on applications for licenses and permits. The Michigan Liquor Control Code and the rules of the Commission provide local government and local police agencies authority to weigh in on applications. So the bottom of this slide, I have a link. This link is going to take you to the local approval chart, which is this quick and easy guide to know what kind of licenses and permits require what types of approval. To give you an idea of what that's going to look like once you go to the link, I put a screenshot of one of the pages, which you can see on the top says on-premise transactions. So this is an on-premise report. And it talks about how you could see on the top part, is local legislative body approval required? Is local police approval required? Is local legislative body or police opinions required to be considered? Is an MLCC investigation required, and whether they have to pay inspection fees and what those fees are? I find this chart very helpful and refer to it frequently. I'm sure that once you play around on this website a little bit and view these links, you're going to find this helpful as well. Just because the MLCC doesn't require local approval of a particular licensing matter, local governments may have ordinances in place to do that. Let's talk a little bit about what you can do. The administrative code that the Commission relies on requires a licensee to comply with all state and local building, plumbing, zoning, sanitation, and health laws, rules, and ordinances as determined by the state and local law enforcement officials who have jurisdiction over the licensee. Well, that's fine and well. The problem is whether or not the Liquor Control Commission takes any action if an ordinance specifically prohibits what an application is requesting. We'll get to that later. You have two choices to control the effect of these legislative and case law changes. You can enact ordinances, whether general public health, safety, and welfare ordinances, or you can adopt zoning ordinance. These ordinances would regulate approval of all licenses or permits, could regulate distance requirements, zoning districts. You have to be careful when you draft these ordinances, so you do have to work with a lawyer to ensure compliance. I'm not just saying that because I am a lawyer. I'm saying it because you don't want to run into a First Amendment problem as the MLCC did in the Deloney case we talked about earlier. There's also issues of preemption. Preemption meaning the state has controlled this area, and so if a community tries to control the same type of regulations, it could be preempted, which is why it's really important for you to work with the lawyer to ensure that your ordinances are enforceable. The second option is to really provide the input that the MLCC is indicating they want from you, and that's under the administrative rule, which sets forth the factors that they'll consider in determining whether to approve a license or a permit. Because the rule specifically listed zoning ordinance, it seems that the MLCC gave more deference to zoning ordinances versus police power ordinances. It was confirmed in a recent case. This was a case involving a gas station that applied to the Liquor Control Commission to sell alcohol in its convenience store. Under the MLCC rules, this request would have easily been approved. However, Bloomfield Township had a zoning ordinance that included regulations that differed from those of the MLCC, and under Township ordinance, the request would not have been approved. The MLCC therefore denied the application because it did not comply with local zoning. The gas station appealed that decision to the Circuit Court and to the Court of Appeals, and the Court of Appeals upheld the ordinance and the decision of the Liquor Control Commission, essentially saying that the local government can enforce zoning ordinances to regulate liquor licensure. Again, you'll note at the bottom, I have properly drafted and enacted. You do still have to be careful about First Amendment violations as well as preemption issues. I'm just going to give you a little brief overview about the quota system because, again, there have been updates to the quota system. In 1933, the Michigan legislature established a liquor license quota system in order to limit the number of businesses selling alcoholic beverages. The number of liquor licenses authorized to a municipality is based on a ratio of licenses to population. The population ratios applied by the MLCC differ for on-premise and for off-premise licenses. For businesses selling alcoholic beverages for on-premise consumption, municipalities are authorized one liquor license for every 1,500 in population. For businesses selling alcoholic beverages for off-premise consumption, municipalities are authorized one liquor license for every 3,000 in population. SDM liquor licenses, which, as you might remember, allows the sale of beer and wine only for off-premise consumption, are not governed by the quota system, meaning there are no limitations. Don't worry, you know me and my screenshots. I've given you some screenshots of an awesome report that the Liquor Control Commission keeps on their website. These are I gave you on-premise, off-premise. Just to kind of walk you through these, you can see once you get to this site, the left-hand side has each county listed in alphabetical order. Under each county, you have a local government unit in alphabetical order. You can find your local government unit. You go across to find the population, which would be the last census report. Authorized means those are the number of licenses. This community is authorized based on the population. The next number is how many have been issued to that community. There also have allocated. Allocated means that there is an application pending and a license has been allocated to that individual. And then available lists how many are available. I wouldn't leave you hanging. I have on the next slide the links to those reports so that you can look up your own community and determine how many are available, how many have been allocated and issued. I find these reports very helpful. There are certain licenses that are exempt from the quota system. There are, for example, resort licenses, redevelopment license, municipally owned golf course licenses, municipal civic center licenses, and club licenses. Why am I giving you this background? Because, of course, there's an update to the redevelopment licenses law. Now, this law dates back to 2007, so this isn't the update. In 2007, the legislature created a new type of liquor license for businesses selling alcoholic beverages for consumption on the premises in redevelopment district or authorities, such as downtown development areas or in redevelopment project areas. These types of licenses are referred to as redevelopment liquor licenses and are exempt from the quota system, meaning they can be issued over and above the number of liquor licenses authorized to a municipality. They do have some specific requirements which must be met by applicants and municipalities prior to issuance. For example, municipalities have to provide documentation demonstrating that they're qualified under the law, and the applicants have to demonstrate that they have tried to get a liquor licenses and there are no available quotas or escrow licenses in the municipality. Redevelopment liquor licenses have an enhanced licensing fee of $20,000. You can change ownership of a license, but you cannot change location. If an establishment operating within a redevelopment license goes out of business, that redevelopment liquor license must be returned to the Liquor Control Commission. So here's your update. Prior to July 2nd, 2014, that law from 2007 that created redevelopment liquor licenses only authorized approval in cities. Now, previous administration of the Liquor Control Commission applied that law to cities, townships, and villages, despite the language of the statute that said cities. This current administration, as we are seeing, has been really following the letter of the law, refused to do so. So, thankfully, our legislatures reacted with the adoption of Public Act 270 of 2014. This act allows the MLCC to issue redevelopment liquor licenses to townships and villages. So there was a gap of a few years there where townships and villages were not authorized, but you've gotten that approval back. So if you're interested in a redevelopment district and redevelopment liquor license issued to you, work with your lawyer on getting all the necessary paperwork together. We do have another new piece of legislation. That's Public Act 236, came out in 2013. This allows for conditional liquor license. Conditional liquor license may be issued to an applicant seeking to transfer ownership or interest in an existing liquor license at the same location to sell alcohol for consumption on or off the licensed premises, or an applicant seeking a new SDM liquor license at a new location. This new law provides that the MLCC must issue a conditional license within 20 business days after receiving a completed application. A conditional license is valid for 1 year, but it expires 20 business days after the Liquor Control Commission issues an order of approval of the permanent liquor license, assuming they do get approved. One final change that happened in 2013 was authorization of the transfer of SDD liquor licenses anywhere in the county in which the SDD license is located. So prior to this act, SDD liquor licenses had to stay within the community where they were authorized. So if a community ran out of liquor licenses, you can't go outside of that community and transfer an SDD liquor license into that community. Well, now you can. Now, Public Act 237 of 2013 allows transfers within the county, so into your community within the county, but into your community, over and above any authorized liquor licenses based on your population. What I've been seeing, and probably what you have been seeing, is really these SDD liquor licenses are becoming more expensive because now you can transfer them into a community that needs them, or at least applicants feel they need them, where they otherwise would not have been able to because they're at their quota. The Liquor Control Commission is going to send a municipality a notice when an application is filed. Again, it's not going to give you the forms that need to be completed, such as resolutions or police investigation forms that it used to, but that will have to come from the applicant. So once you receive that notice, you're going to want to take a look at where the application is in the process with the Liquor Control Commission. You're going to want to stay on top of the approvals. And at this point, as soon as you receive this notice, is when you're going to want to react, whether it's by objecting under the rules or whether it's by identifying an ordinance to the commission that is being or would be violated if the application is approved. You can monitor the status of any application pending before the commission by visiting the website. I've included the link for you. I think that I visit this on a regular basis. This is an awesome tool for applicants, for governmental units, for licensees. You can search by name, business ID, request ID, address, mailing address, or even your governmental unit where the proposed business is going to be located. It's very user-friendly. Once you find the application that you're interested in, you can click on the business ID and it will pull up and show you where it is in the process. I also gave you a screenshot of what it's going to look like. You can see, you can put in a request ID, which should be listed in the notice you get from the commission, assuming you get a notice. You can list it by business ID. You can actually just type the name of the business in. You can click your governmental unit. Any way you want to look it up and hit the word submit down there, and it'll pull up all of the relevant applications that may be pending. Once you get into those applications, there will be hyperlinks with request IDs. You click the hyperlinks and it will take you to the next page that shows you the status. Well, I am way early here, but I just wanted to summarize by telling you, despite the scuttlebutt, the Liquor Control Commission has not completely stripped local government of its authority to regulate liquor licenses. The Liquor Control Commission still requires local government approval prior to issuing new on-premise liquor license, and it continues to consider the opinions of the local residents, the local legislative body, and the local law enforcement agency in its decision-making process. In fact, all approval orders include the following language. Under Administrative Rule 436-1003, the licensee shall comply with all state and local building, plumbing, zoning, sanitation, and health laws, rules, and ordinances as determined by the state and local law enforcement officials who have jurisdiction over the license. Approval of this license by the Michigan Liquor Control Commission does not waive this requirement. The licensee must obtain all other required state and local licenses, permits, and approvals before opening the business for operation. Failure to comply with all laws and rules may result in the revocation of the approval contained in this order. So what happens if the Liquor Control Commission approves and the local government does not due to an ordinance in place? It's probably what you're thinking. It's what I was thinking. Honestly, I don't have a clue. It has not been challenged yet. What we are seeing is a trend that the Liquor Control Commission is approving regardless of existing ordinances. Essentially, they're letting you, the local governmental body, deal with your ordinances, and they are dealing with their ordinance, their laws and rules. I can't tell you that that's the way it is going to be and that's the way it's going to continue. It's a trend that we're seeing. It's not always. There are some times where they recognize the ordinances, such as that Maple BPA case in Bloomfield Township. You do need to make sure that your ordinances are not preempted and that they are effective and valid if you want the Liquor Control Commission to honor them. Even if the Liquor Control Commission does not, as long as they're properly enacted, not preempted, and valid ordinances, you can enforce your own ordinances. I am happy to answer any questions that you have, whether you have questions today or if you want to follow up with me at a later date, I'm happy to assist you. Looks like we have a question. You said, assuming you get a notice, why wouldn't the municipality receive a notice of an application? The Liquor Control Commission is only going to send you a notice if an investigation is required. So if you want to look at the on-premise report, I gave you the link to that. That on-premise report that shows you the different types of licenses, whether local legislative body approval is required, etc. It has a slot that says MLCC investigation required. If an MLCC investigation is required, then you should get the notice of a pending application. If MLCC investigation is not required, you will likely not get the notice of a pending application. If anybody have any other questions? Okay. It looks like that's all. Please, if you have any questions, send me an email. Call me. We're happy to address any questions. Sorry, we cut you out early. It's only half. It's 12:30. Thank you for coming and enjoy your lunch.